hearing in the appeal Deslauriers and another, and Guardian Asset Management Limited.
Morning, Mr. Keeling.
Good morning, my lords. I'm proposing to take about 15 minutes to wrap up the main appeal, and then Miss Lindsay and I will be moving to the Victoria Square appeal. The first topic that I want to cover is the question of inducement, and I'll invite you, if I may, to look at the witness statement of Mrs. Deslauriers in Bundle 1 at page 197. And in order to be able to identify what the alleged inducement was at first instance, you have to have the background to the paragraph where she says how she was induced. And therefore I propose that your lordship should look at page 197 to paragraph firstly 8. And when you read this, it's the last 3 lines of 8. When you read this, you should bear in mind, of course, that the learned judge at first instance, having heard the oral evidence, said that and concluded that GAM had not pitched for the business and hadn't pitched or pursued aggressively the business. This was a discrete loan. So if you begin at the end of paragraph 8, you'll see that the allegation there in the statement is that Mr. Saint-Cyr and Mr. Ramdeen made a pitch to handle the financing of the project. Now, this is a point that I've emphasized in the past, and I'll just emphasize it once this morning and never emphasize it again, unless I absolutely have to. So here you have...
That's a pretty qualified undertaking.
Not a very encouraging...
Well, I reserve the necessity, the necessity rather than the right.
Right.
And so I won't make the same comment about the first sentence of the next paragraph, which I would also invite you to read.
Right, yep.
And then I'd like you to have a look at paragraph 11, which is the non-disclosure or the misrepresentation, however you like to characterize it.
Yep.
But the important paragraph is paragraph 13, my lords, where, as I understand it, the alleged inducement is set out.
Yes, exactly.
And you've got to read what she says there in combination, in the sense that it's not just one matter that allegedly induced her, it was a combination of matters that allegedly induced her. The most important was based on the understanding that the claimant's representative indicated that the only difference between the claimant and a bank is that payoff could not be done before 1 year. Yep. They didn't indicate any limitation on their lending capability, and that we would be returning for funding at the completion of the construction phase, and I want to emphasize that last.
We understand that's distinct from the internal fitting out phase, yeah.
Yes, but it's also that we would be returning for funding. There was no uncertainty about this. This was a matter of certainty. We agreed to move, and note, my lord, our business from Republic Bank to the claimant. Now, while you read that witness statement, you'll also bear in mind, of course, that this was a very carefully drafted witness statement. I say that not because, as you know, they are always very carefully drafted, but this witness statement, my lord, was actually done by the attorneys, in Mrs. Deslauriers' words. If your lordships could just bear in mind page 412, where she in fact disavows one of the paragraphs in her witness statement. Not a terribly important paragraph, it must be said, but if your lordships look about 2/3 of the way down in the cross-examination of Mrs. Deslauriers, page 412, the question is, this is your witness statement. Answer, I know, but you're fully aware that it's done by attorney's right, and I'm reading it now, and like, what the heck is Anand, who's, I think, her attorney, saying?
That's
Well, unfortunately, she didn't make the same observation in relation to paragraph 13, but there it is. You have paragraph 13, and one wonders...
a realistic view about the relationship between witness statements and reality.
Well, indeed, my lord, but Anand, whoever he or she be, is obviously the author of paragraph 13, as much as Mrs. Deslauriers is.
I see, right.
But if you look at paragraph 13, you've got to look at it carefully. The inducement, my lord, was allegedly based, or the alleged inducement was based, on the alleged, what appears to be a mutual understanding, that she would be back for financing or funding at the completion of the construction phase. Well, if that falls away, my lord, if that falls away, then she can't say, and nor can Mr. Knox say, that there's proper evidence that she was actually induced by less than that which she claimed to have actually induced her. It follows she wasn't actually induced by the statement. She's not saying she was actually induced by one part of what she says here. She was actually induced by all three together. And once you take one of those things out, the rest falls away. Put negatively, which I now will do, the Deslauriers case on inducement was never advanced at trial on the basis that GAM had no obligation to provide any more funding. It was never advanced at trial on the basis that GAM hadn't undertaken to consider the possibility of extending additional funding. And it was never
had undertaken. It was never advanced on the basis.
It was never advanced on the basis that they hadn't. In other words, it was under...
Yeah, I see your
I'm
point,
so
yes.
sorry.
It was always advanced on the basis
my double
that they
negatives,
had, yes.
exactly.
Never put in the alternative.
Exactly, my lord.
Yeah.
I should have made it rather more simple. And lastly, in other words, it was not advanced on the basis that they had done no more than enter into a discrete loan transaction entailing the advance of a sum certain, which required payment by a terminus ad quem, plus interest. In other words, it was never advanced on the basis that GAM merely knew that Mrs. Deslauriers might come back with a request for additional funding at the end of the 18-month period if she needed more money to complete the project. That was not the basis of the actual inducement case.
Yeah.
Period.
So, well, I think we've got your point, yes.
And that's the only point that I now wish to make on that part of the case. And that part of the case, my lords, is the pre-contractual part of the case, which I covered yesterday. So turning to the post-contractual part of the case, we say, with a certain degree of firmness, as you would expect, that there was no duty in relation to any alleged misstatements occurring post-contract. And we would, as it were, commend to your lordships paragraphs 65 and 66 of our written case. I'm not going to bore you with reading all that out aloud. But there are two documents, my lord, which I think are those upon which the Deslauriers rely in some form or other. They're both in volume 1. The first is at 223, which is a July exchange between Mrs. Deslauriers and Mr. Ramdeen. This is the one that I think my Lord Mance referred to by reference to the Duke of York.
Yes.
And it's rather like having a facility, my lord. I don't know, maybe banks extend you markedly good facilities, whereby you have a facility of £1 million, and you can draw down on it and pay back on it, and it's just a rolling, as it were, credit. And this is what Mrs. Deslauriers, according to Mr. Ramdeen, what he thought she was asking.
Yeah.
Because what it appears to be suggesting upon a reading is if I pay down on the loan, can I then draw back on the paid down loan as though it is a rolling facility? And there is, I think, somewhere in there, the possibility that she might want to draw down more than she's paid back.
Yes, well, that's certainly there. That's the 2 million, isn't it?
That's the 2 million.
Yeah.
Well, the answer is, from Mr. Ramdeen, he quite clearly didn't quite understand what was being requested, because he says, remember, your facility is 18 months, maturing April 2, 2009, with an option to repay on the anniversary date, my lord, of the loan. That's October 2nd, 2008. Paying down the facility and then topping back up is kind of confusing to me, as you'd have to find the cash to pay down and then just get it back. So he understands, or rather, he doesn't understand that this is the type of facility that Mrs. Deslauriers is inquiring about. He understands that this is a loan agreement which requires to be paid down by the 2nd of April with an option to pay upon the anniversary date or repay upon the anniversary date and thereafter. And he doesn't understand the concept of paying it down only to draw it back up. And he says, I'm not clear as to what you want to do.
Yeah.
There is nowhere here, my lord, from which, in my respectful submission, a person reasonably circumstanced, as was Mr. Ramdeen at the time, could have understood that she was relying, my lord, upon GAM for further funding. She might have asked for further funding. Anyone can go to a bank, my lord. Your lordships, when you were comparatively young and buying your first house, probably went to a bank and said, can I have some money? Anyone can go to a bank and ask for some money. But that doesn't mean to say that there is any understanding that the bank will consider your application, consider it favorably or unfavorably. So all she's doing is actually asking for more money, not, oh, by the way, in accordance with our mutual understanding, could you please provide me with the money that you said that you would or might?
Right, well, that document, is it?
That's all.
What about the other one?
229. To 30. You should start at 226 to 7, I suppose. 226 to 7. She's there, well, you've gone through this document before. She's there asking whether GAM would rather be paid off or would rather prefer to keep the business longer. Either way, my lord, is fine with me.
Yeah.
So the idea that she's actually relying on GAM for anything in relation to funding, or anything substantial in relation to funding, is, in our respectful submission, unsustainable on a realistic view. That's November, and as your lordships know, on the 26th of November 2008, reference is 229 to 30. GAM said they'd rather be paid off. And if your lordships needed, Court of Appeal reference paragraph 42, volume 2, 693, that's page 693, if you need to have a look at that or have any desire to look at it at any future stage. And finally, my lord, in this context, post-contract, there is absolutely no realistic legal possibility that GAM was acting in a professional advisory capacity, undertaking any duties of care to the Deslauriers, who were always and merely borrowers of a finite sum. Indeed, my lords, they still are borrowers of a slightly less finite sum, as it accrues daily.
Right.
So next topic, my lords, lending limitations. Were there any lending limitations that made GAM different from a bank, alternatively a large bank, such as to falsify the statement relied on? Well, one starts from first principles, my lord. The burden of proof was on the Deslauriers. If there was not the evidence before the court at first instance in relation to lending limitations and in relation to a comparison between such lending limitations as applied to GAM and such lending limitations as applied to other banks, then that is a problem for the Deslauriers. That is not a problem for my clients. There's been no suggestion, my lords, that the Deslauriers were unrepresented at any stage before the trial date of this case.
Yeah.
Paragraph 67 of Mr. Justice Rahim's judgment, volume 1, page 440, made it clear that he was unable to come to any conclusion as to what, if any, lending limitations applied to GAM. Ergo,
Well, it said that the evidence on that was
uncertain.
Well, it was given, but it said that it wasn't open, really, in light of the fact that no positive case was pleaded, I think.
Yes, well, he says, my lord, paragraph 67, second line,
Yes.
lending limit of the claimants, if there was one.
Yeah. Well, he makes a finding, but should the evidence have been admitted in the absence of any prior positive case being put forward by your clients on this point?
Your lordship just
Well,
repeated.
I think the point made against you is that no positive case was pleaded or
Yes.
advanced by your client to suggest that it didn't have a lending limit.
I accept that, my lord.
Well,
but that's actually not the answer to the point, because the answer, let's just assume there was a lending limit. Was it different from, materially different from, that of any other bank?
I see. So it's if there was one. So he's assuming there might have been a lending limit.
Yes.
It could have been a lending.
Could have been anything.
Yeah.
And I don't know who these large banks are, what their capital bases are, what their capitalization is or was, what their issued share capital was. I have absolutely no idea. And certainly Mr. Justice Rahim had no idea because there was no evidence. So if the basis of the, and it is, the basis of the, if the basis of the alleged misrepresentation was a difference between my client's lending capacity and that of other banks, it is incumbent upon the person making that allegation to prove what the lending capacity is. But even if there is evidence of what the lending capacity is, there has to be a comparative exercise between whatever that is and whatever it is being compared with, namely that of other banks. And that step was never taken. So the question, my lord, was, did any lending limit that applied falsify the statement? There is no evidence to suggest that it did. The Deslauriers have suggested that there was an internal lending limitation. They rely on the email of the 9th of January 2009, that's bundle 1, page 236. And if your lordships look at bundle 1, 236, you'll see there that reference is made to the investment committee. In fact, forgive me, that's a wrong reference. It's the right reference, but I got it wrong. We need to follow the guidelines set by our regulator. For failure to do so would run the risk of our license being revoked. If our balance sheet was much larger, then the additional $6 million would not be an issue. My lords, I don't know if you've ever been rejected for a loan, but there are ways of rejecting people for loans. You can either do it rudely by saying you're a terrible risk and we loathe you, or you can put it more politely and say, in view of the prevailing economic circumstances, we don't think that we can really extend you a loan. Or you can say something like this. We have absolutely no idea, my lord, that this actually does prove that there was a specific lending limit that applied, as opposed to Mr. Ramdeen simply saying to Mrs. Deslauriers, and there's no evidence to this effect, so you can dismiss everything I say as pure speculation, but the reason there's nothing to this effect is because this wasn't the subject of great cross-examination, if I can put it that way. So, but the question is, my lord, that when you read that, you have to read that in the light of Mr. Ramdeen's witness statement as well. And if you could turn up page 76 of bundle 1 and go to paragraph 26.
Sorry, Mr. Keeley, page?
It's page 76, my lord, of bundle 1. Paragraph 26.
Yeah.
If you could just read that to yourselves, you've got to read the email in that context, where he explained to Mrs. Deslauriers that if GAM were to loan an additional sum, forgive me, of $6 million, this would result in an exposure in relation to one single client, equivalent to GAM's entire issued share capital of $25 million, and I didn't think that GAM's risk committee would approve such a transaction. So this is what we're talking about, my lords. Now you may say, oh, well, that's quite a small limit, but actually it isn't. We're talking about exposure and appetite to risk of any bank. Do you want to expose yourself to one particular client for what is a potentially large sum of money comparative to your issued share capital? It doesn't mean to say, my lord, or my lords, that you won't extend 1/10 of the requested loan to 30 different borrowers, because then, of course, you don't have a concentration on one borrower. You have a diversification of risk. So if one borrower fails...
No, we've got the point. Yeah.
Everything, you've got the point.
Yeah.
The Deslauriers case, gosh, you're rushing me, my lord. The Deslauriers case before the courts below.
Well, we may not have your experience with banks, Mr. Keeley, but we do have some experience.
I'm sure your lordship's borrowings have been much more extensive than mine. The Deslauriers case
Right.
before the courts below, I meant that the other way around, was a positive case that there was a limit based on the Financial Institutions Act. Sorry, I ought to make that more clear. The Deslauriers ran the positive case below, that there was a lending limit based on the Financial Institutions Act of 1993.
Yes.
And I'm going to give you the references in Bundle 1 to pages 290, 295, 368, and 464.
Right. 290, 295, 368.
And 464. Now, if your lordships don't want me to pick up just one of those so that I can show you,
Yeah, it shows at 1, yeah.
I'll show you one. If your lordships go to let's go to maybe, forgive me, 368. No, this is in the witness evidence. Yes.
Right.
It's a question about halfway down. This is Mrs. Deslauriers
Yeah.
cross-examining. Just using common sense, Mr. Ramdeen, do you think it's logical, credible, that a land developer in business for 30 years with a $60 million project, as we all agreed, is going to come to a finance company that can only lend $32 million total? That was the question. And so that you can see, my lord, at paragraph and then, my lords, if my own friend Miss Lindsay reminds me, 366 to 7.
Yeah.
366 to 7, where the case is put by Mrs. Deslauriers, the bottom of 366, about the central bank guidelines, the penultimate question on the page, 25% of capital base not to be exceeded to one person. Mr. Ramdeen says he's not familiar. And then she goes through all the figures, my lord. In other words, you have a capital base or shareholders' equity of 130 odd million. You see that from the top.
Mm-hmm.
And then in the middle of the page, there is a central bank guideline, which I just read, that you cannot lend beyond 25% of your asset base, but Guardian's asset base is 130 million, 25% is 32 million. So that is the case being put. And if your lordships could just bear in mind page, I think it was, forgive me, my lords. Well, if you go to 464, which is actually part of the Court of Appeal submissions, where the learned author of this document says it doesn't really matter what the lending limit is, whether it's 24 or 30 million.
Well, because the case is that it's a 60 million commitment, effectively, or commitment to a 60 million project, I suppose.
Yes.
I think that was Mrs. Deslauriers' explanation to the judge when she was asked why she was questioning about the...
Yes. This is, by the way, my lord, must have been before the duck was killed, because this is actually the submission to the Court of Appeal,
Right.
but we're still talking about a $60 million
Yeah, quite.
cost. Anyway, your lordships have the point.
Yeah. Right, now you've been...
And so the last point I want to make on that subject is, yes, we were subject to the Financial Institutions Act. Yes, our borrowing limit in relation to any one borrower was 25% of our capital base. And yes, that was exactly the same level in proportionate terms as enjoyed by every bank.
Yeah.
Therefore, our lending limitation was no different from any bank or any different from any large bank. Of course, if you're talking about nominal terms, I have not the faintest idea because there was no evidence before the judge as to what any other bank's capital base was or wasn't. So we're no further advanced.
That one isn't different, but Mr. Knox doesn't rely on that one, does he?
No, he doesn't. He relies on something else.
He relies on the sort of 24 millions, and what you say about that is that there isn't really evidence that there was such a limit, and that there is evidence that it was just a banking judgment that that
Yes.
would be overexposure.
Yes, exactly so. So I turn to causation very quickly, if I may. There's no evidence, my lord, or cogent evidence that the Deslauriers could have got the funds anywhere else, even if they'd gone elsewhere for finance in 2007, let alone 2008, and certainly not in 2009. The Deslauriers advanced no evidence before the judge at first instance from any banks or any other forms of financial institution. And your lordships know that despite what they were contemplating in 2008, they never went or found anybody who was otherwise interested, otherwise willing to take on the project to the extent of actually committing to taking on the project. Certainly not in 2008. Which brings me very quickly, although it's not necessarily quite the same topic as of causation, but it's probably loss. I just want to mention loss of a chance. Case was never advanced below, but in the absence of any evidence from any bank as to what their interest was or might have been or might not have been, there is no purpose in even discussing loss of chance. Insofar as anyone might rely upon Mrs. Deslauriers' evidence, then, in my respectful submission, Mrs. Deslauriers' evidence is shot to bits. You can't rely upon Mrs. Deslauriers' evidence for virtually anything. And indeed, the judge at first instance, although he wasn't quite as rude as I have just been, made it clear that that was his view as well.
The causation, they have to show, do they, not only that if they'd decided not to use GAM, they would have found more funding, or somebody else who would have given them more extensive funding, but they also have to show that they actually have to show that they would have decided to use someone other than, or tried to use someone other than GAM, i.e. that the representation was so important that
Yes.
it would have tipped the balance, not merely have been an inducement to go with GAM, but it actually would have been one but for which they wouldn't have gone with GAM.
Exactly, and they have to go further,
Yeah.
and they have to prove that what would they have done with the other bank? If you can judge what they would have done with the other bank by reference to what they did with us, they would have got a loan for $18.6 odd million, repayable in a year or 18 months' time. Would they have got an undertaking from that bank? Well, they didn't get an undertaking from us because they didn't ask us. So why would they have asked for an undertaking from another bank in relation to future funding? In fact, probably what would have happened, if anything, if they could have gone to another bank, is probably no different from what occurred in relation to GAM. Therefore, there is absolutely no certainty, let alone probability, that they would have been in any different a position from the position which they find themselves or found themselves in 2008, 2009 vis-à-vis GAM.
Would they have to demonstrate that they would have got an undertaking from the outset, or would it be enough to demonstrate that they would have borrowed from somebody who had the money to lend it to them if a subsequent application was favourably viewed?
They would have to go further and prove that they would have got the additional finance.
Because otherwise they haven't avoided the loss.
Exactly.
In the present case, let us... Is there a point lurking somewhere here about, based on the principle that you measure damages on the basis that a party would behave in the manner most favourable to itself? If it hadn't broken the breach, then it would have if it hadn't breached the contract, it would have conducted the contract and used its terms in the manner most favourable to itself. In other words, I just wonder whether here, since we're not
dealing with a promise to provide finance, whether it couldn't be said that even if GAM's representation had been true at the end of the day, it was under no obligation to advance money. But maybe that's a bit far-fetched in this context.
That principle certainly applies, my lord, and you have
I can't think. It's, in the context of misrepresentation, it's a bit difficult to apply.
But even if
in
it
the
applies,
face of the email which says if we'd got a bigger capital base, the 6 million would be no problem, isn't it?
Yes.
yes.
But I mean,
It's not a lurking principle, my lord. It's a principle that doesn't apply. And in any event, if it is a principle...
It doesn't apply because they've said that what they would have done. I mean, the normal principle is that if you said how you would have operated the contract, unless you were obliged to do so, it's assumed you would have operated in fact in the manner most favourable to yourself.
Exactly, but there is no contractual term in this case
No, so it's
of which they can take advantage. If one looks at the loan agreement, or whatever it's to be called, the promissory note, and finds a term of which they could have taken advantage.
Who's they there?
Well, it would be actually my clients.
Your clients, it would, yes.
It would be my
If you
clients.
accept the principle doesn't apply, it's a red herring.
Well, I haven't given it the thought that perhaps it deserves, but giving it such thought as it
was only a thought that occurred to me.
as I've had the opportunity, I think it's
Right.
a red herring.
Are we...
Yeah, I'm running, galloping. Novus Actus Interveniens, 2009, completely new story. That also fits, my lord, doesn't fall within scope of duty. In other words, our duty was to give information, my lords, not to advise. We never undertook any duty to finance the project, which is something that the Deslauriers accept. The losses that they allegedly sustained were because they didn't or couldn't find the finance for the project. The losses, therefore, that they sustained don't fall within GAM's scope of duty. Further explanation, see our case at paragraph 78-79. Now, I know rattling through this is not hugely helpful to your lordship, so you'll have to forgive me. But needs must.
No, we got it in your case.
Right. And that also, all these different legal concepts all come together. There's one stream through them. It's rather like remoteness. Was it reasonably foreseeable that if the tort hadn't been committed and there were lending limits, the Deslauriers could not have got the funding elsewhere when they needed it? Well, the CLICO was unforeseeable. This is not something that can be laid at our door. See the Samco case. And finally, my lords, the question, well, actually, it's not finally, forgive me. It's been proposed that there could be, if your lordships were against me on the counterclaim, your lordships should obviously find against me and then remit the matter for an assessment of damages. Well, you know what I'm going to say. I don't even know why I bother. There's no order for a split trial.
Yeah.
This was always intended to be a final and complete trial. There never was any satisfactory evidence of damages. See paragraph 86 of our case. We are now 10 years after the loan was extended, and 6 years after the trial. You've got the points. And then we have to try and reconstruct the evidence 10 years on with, if necessary, expert evidence from banks or bankers in Trinidad and Tobago, or Tobago, who may or may not have records and who may or may not have great recollections of 2007, 8 and 9.
Was there an application to the Court of Appeal for remission? In other words, did they put forward that as an alternative?
I don't recall.
That was what we put forward as the suggestion, not an alternative. We said that's what the Court of Appeal should do.
Yes, I
it
think,
was
yes.
frankly unopposed as a suggestion.
Yeah, right.
There was no argument about loss at all.
Well, it's opposed.
Yeah, right.
Don't care what happened below. I'm opposing it. Root, line, and whatever. Hook, line, and sinker. Anyway, and if there is a remission, my lord, there are no exceptional circumstances justifying a stay in the case of promissory note. See paragraphs 91 et sequitur of our written case. So the final topic, my lord, under the main appeal is that of alleged unfairness. Now that's by the judge in his management of Mrs. Deslauriers' cross-examination, as I understand it. That's not a free-standing ground of appeal.
Can you ask Mike?
Do you want to hear
Don't need to hear them.
I don't think we need trouble on that.
Right, my lords. I will now turn to the Victoria Square appeal. Will your lordships give me just a moment to get rid of some documents? Now, just as you would expect, I'm going to tell you that virtually everything I'm going to say, but not all, is in our written case, which is probably too long-winded a document for your liking, but it exists. We rely wholeheartedly on Milroy and Lord, Richards and Delbridge, and my Lord Briggs's decision at first instance in Curtis and Pulbrook. I'm going to take this quite fast, but I hope comprehensively.
Do we want to look at those?
Well, yes, I think you do have to.
Right. Well, I meant now, obviously.
Yes, if you could have a look then at Milroy and Lord.
Tab 14.
Thank you so much.
1216.
Thank you, my lord. This was a case, my lords, as you will see, where TN, that's Mr. Milroy, I think it is, executed a voluntary deed purporting to assign 50 of his shares in the bank.
Yes. To SL to be held.
To SL to be held by him on certain trusts for the benefit of the plaintiffs. And the only way in which you could effect the transfer, my lord, was by entering the books of the bank, and no such transfer was ever made.
Though the recipient had a power of attorney under which he could have done it.
Yes, exactly so. You get more of the details if you turn over the page, in fact, my lord, to page 1186 of the report 1218 of the volume. The bill was filed by Andrew Rowe McTaggart Milroy and Eleanor Rainey, his wife, formerly E.R. Dudgeon, for the purpose of having new trustees appointed of a voluntary settlement made by the late Thomas Medley for recovering 50 shares of the Bank of Louisiana. And if you just go a few lines further down, you can forget about the North American fire insurance, my lord. And the bill also prayed that the defendant, Samuel Lord, the trustee named in the settlement, might be decreed to make compensation to the plaintiffs and other parties entitled under the settlement in respect of his having given up the certificates for the shares to the defendant Otto, the executor of Thomas Medley. So after having made a settlement, my lord, the late Thomas Medley then died. And the settlement is then, know all men by these presents that I, Thomas Medley, on account of the love and affection, etc., that he has for Eleanor Rainey, his niece, do convey, or rather have conveyed, transferred, set over and delivered, and by these presents do convey, transfer, set over and deliver unto Samuel Lord of the city and county of New York 50 shares of the capital stock of the Bank of Louisiana, now standing in my name in the books of the said bank. And then it goes on about 3 lines further down, to have and to hold to the said Samuel Lord and his legal representatives upon the trusts and conditions following to it. And there they are set out. And if you go to the bottom of the page, the deed poll was under the hand and seal both of Thomas Medley and of the defendant Samuel Lord. At the time of the execution of the deed poll, Samuel Lord held a power of attorney from Thomas Medley, whereby Medley empowered him to take possession of basically everything. Next paragraph, according to the constitution of the Bank of Louisiana, the shares in the bank were transferable in the books of the company and all transfers were to be made by the proprietor or his lawful attorney, the certificates of stock being surrendered at the time the transfer was made. And then if you go to the next paragraph, in 1855, the plaintiffs intermarried, in other words, married each other, with the consent and approbation of Thomas Medley. In the month of November in that year, Thomas Medley died, having by his will bequeathed to the plaintiff a legacy of £4,000 and appointed the defendant Otto to be his executor, who duly proved his will. After his death, the defendant Lord delivered to Otto the certificates, in other words, for the purposes of the execution of the estate, rather than in accordance, as it were, with a deed poll. At the bottom of the page, Vice-Chancellor Stewart, at the hearing of the cause and of a petition presented in it, etc., made a decree declaring that the 50 shares were bound by the trusts declared by the deed poll. About 5 lines from the foot of the page, the decree proceeded to appoint a new trustee and to order the defendant Otto, an executor of the will, to transfer the 50 shares into the joint names of Lord and the new trustee to be held by them upon the trust of the said deed poll. If your lordships could go to the judgment of Lord Justice Turner, I don't mean any disrespect to Lord Justice Knight Bruce, but it is the former's judgment which is that which is always cited. So it's the right-hand side, it's 1189, bottom of 1221. Under the circumstances of this case, it would be difficult not to feel a strong disposition to give effect to this settlement to the fullest extent. And certainly I have spared no pains to find the means of doing so consistently with what I apprehend to be the law of the court. But after full and anxious consideration, I find myself unable to do so. I take the law of this court to be well settled, that in order to render a voluntary settlement valid and effectual, the settler must have done everything which, according to the nature of the property comprised in the settlement, was necessary to be done in order to transfer the property and render the settlement binding upon him. He may, of course, do this by actually transferring the property to the persons for whom he intends to provide, and the provision will then be effectual. And it will be equally effectual if he transfers the property to a trustee for the purposes of the settlement, or declares that he himself holds it in trust for those purposes. But in order to render the settlement binding, one or other of those modes must, as I understand the law of this court, be resorted to. For there is no equity in this court to perfect an imperfect gift. The cases, I think, go further to this extent, that if the settlement is intended to be effectuated by one of the modes to which I have referred, the court will not give effect to it by applying another of those modes. If it's intended to take effect by transfer, the court will not hold the intended transfer to operate as a declaration of trust, for then every imperfect instrument would be made effectual by being converted into a perfect trust. These are the principles by which, as I conceive, this case must be tried. And he then goes on to look at the facts of the case, says the question therefore must be whether a valid and effectual trust in favour of those objects, I'm sorry, I should start at the beginning. Applying then these principles to the case, there is not here any transfer, either of the one class of shares or of the other to the objects of the settlement. And the question therefore must be whether a valid and effectual trust in favour of those objects was created in the defendant Samuel Lord or in the settler himself as to all or any of these shares. Now it's plain that it was not the purpose of this settlement or the intention of the settlor to constitute himself trustee of the bank shares. The intention was that the trust should be vested in the defendant Samuel Lord. And I think, therefore, that we should not be justified in holding that by the settlement or by any parallel declaration made by the settlor, he himself became a trustee of these shares for the purposes of the settlement. by doing so, we should be converting the settlement of the Parole Declaration to a purpose wholly different from that which was intended to be effected by it. And as I've said, creating a perfect trust out of an imperfect transaction. So what had happened, my lord?
Well, I think we've probably got the facts.
Got the gist of that. So
It's a pretty bleak application of clear principles, isn't it? I just wondered whether one wouldn't strain even more than Lord Justice Turner today by use of something like possibly a stopple, I don't know. I mean, it does seem a bit tough on Miss, or Mrs. as she had become, Medley, yes, Dudgeon, Miss Dudgeon originally, now Mrs. Someone, yeah.
There's nothing in Milroy and Lord, is there, Mr.
Milroy, yeah.
Which prevents a settlor from adopting in succession one or more than one of the three methods of creating an effective gift.
That's absolutely right.
So, for example, a settlor could say, I am settling this property on trustees for the benefit of my donee, but until those trustees are in place and duly appointed and the property has been transferred to them, I will treat myself, I will hold the property on those trusts in the meantime.
Or alternatively hold it on trust for the future trustees?
Well, I was simply going to say on trust for the beneficiaries in the meantime, but you could say on trust for the future trustees, although they're only trustees, not beneficiaries. On these trusts for the meantime, let's put it that way. There'd be nothing contrary to Milroy and Lord in doing that, would there? And the assignment in Milroy and Lord didn't contain any indication of such an intention.
You're absolutely right. You can do both sequentially, and as we say in our I'm so sorry, you're going to ask me another question.
No.
As we say in our case, there was absolutely nothing to prevent Mrs. Deslauriers, in Recital 5, adopting the words that she had just used in Recital 4, and saying, pending the transfer, I hold this property on trust. She might even have said as a bare trustee if she knew what that meant, but she could have said, I hold the property on trust, or I hold, she doesn't even have to say what it is, the object of the trust is, because it probably would have been sufficiently clear. I shall hold, or I do hold, the property or the object of the trust as a bare trustee.
Yes.
In which case, not a problem.
She could. But then if the question is whether the document read as a whole contains a sufficient demonstration of an intention that there should be an immediately binding trust, the word trust, generally speaking, doesn't necessarily have to be used, although of course it normally is. When Snell says any form of words will do, providing they sufficiently disclose an intention to create an immediately binding trust.
Absolutely. You don't have to say I declare, you don't have to say on trust, you don't have to use the words but. If you don't use those words, then you have to be able to construe those words as meaning that there is a holding of shares. In other words, there is a holding of the legal estate for the benefit of another party.
Yes.
And
in this case, in Milroy, wouldn't you, in fact, be inclined to resolve the problem today by saying that everything that happened subsequent to the original, a clear attempt to deal with the matter, gave rise to an estoppel, stopping the original settlor from holding, denying that there was a trust in favour of Miss Dudgeon?
no, you wouldn't be able to go that far. Where you might be able to get to, if the facts are sufficient, as indeed my Lord Briggs said in the case that I referred to, Pulbrook. And indeed...
she received the income for years, and some of it passed through the settler and so on. Anyway, sorry, why couldn't it work?
You might be able to get a conventional estoppel.
Yes.
But don't forget, the conventional estoppel has to bind the parties,
yes,
the relevant parties. It can't bind a necessary third party.
No, but all the three parties were party to the subsequent dealings with the dividends and so on. And
then there could well have been an estoppel by convention, but at the moment, my lord...
There isn't here.
Exactly.
On the contrary, here there's no evidence that the trust meant anything in reality at any point.
Well, here nothing ever happened.
Exactly.
But The difference, or the arguable difference between this case and Milroy and Lord is this, isn't it? In Milroy and Lord, there was nothing in the deed of assignment that contemplated the need to deal with a period prior to it becoming fully effective by the complete transfer of the property to the trustees. Because it was assumed that it was a complete wrongly assumed that it was a complete and immediate assignment of the property to the trustees. Here there is an express contemplation that although the settlor is going to transfer the property to trustees, I forget what the words are, as soon as possible, there is a period between the execution of the deed and that second stage, which Recital 5 seeks to deal with.
No.
What's 5 for if it isn't for that?
In my respectful submission, Recital 5 does not seek to deal with that. Recital 5 is an expression of desire that the trust should take, or the settlement by this trust should take effect immediately. And if your lordships could go to paragraph 31 of our skeleton, and perhaps before you read that, just read paragraph 30, if you would, of our case. Sorry, I said skeleton, forgive me. And perhaps, I'm sorry to be jumping, go up, if you would, my lords, to paragraph 29. I'm going to start, if I may, slightly earlier. If not paragraph 26.
No. I think you're...
Right. Paragraph 26. Adopting the words of previous judges, this is not a case where a transaction can fairly be construed, whether by applying a benevolent construction or otherwise, as a declaration by Mrs. Deslauriers, pending she had divested herself of her beneficial interest and was purely holding the property on trust in favour of her children, or as a bare trustee.
Well, the trust gave her a life interest anyway, didn't it?
It did. Gave her a life interest.
So she wasn't, even if she transferred the property, divesting herself of any beneficial interest.
Well, she...
And as for the day-to-day affairs, as a life tenant, she'd be in more or less the same state as she was before, with the right to the benefit of the property until she died.
It depends how you construe the settlement. If you construe the settlement as a trust whereby, in fact, she didn't divest herself of anything during her lifetime, which is one construction, then, because she retained the capital until her death and was entitled to the income, then, in fact, there has been no division between legal and equitable estates, because it's a principle of law, my lord, that if they are vested in the same person, then there is no trust that can possibly apply, because there's an absolute ownership in one person. If, on the other hand, she only had, as it were, on the terms of the trust, an equitable interest, in the sense of a beneficial interest in relation to the income, then certainly she will have, through the terms of the deed, my lord, of which her children would be the trustees, acquired or had vested in her a beneficial interest.
I was simply looking at your words and was purely holding the property on trust in favour of her children, which the settlement didn't purport, as I understand it, to do.
Well,
It's for herself and her children.
Yes.
it would, your lordship's right. Your lordship's right.
But,
Yes, it would be, but it might also be that as a bare trustee, she is a trustee of the trust of which her children are to be the trustees. That's as a bare trustee. This is of the double-decker, the layered cake.
What's the point of recital 5, Mr. Keeley?
Well, the recital 5, my lord, we explain what it is at paragraph 30.
Yeah.
31.
31. But
And perhaps...
Which is the case you rely on, the case you rely on for the words, even if there's an express intention that the gift be immediately effective?
That's Richard, that's That's Richards and Delbridge, my lord. It's at tab 22. I was going to take your lordships to that,
Yeah.
actually,
Yeah.
in a moment. But it doesn't matter. It's at divider 22. Which followed Milroy and Lord. It was going to be my next case, my lord.
Yes, we got it now.
My lord, you see at the beginning, Edward Benetto Richards stated, and he was the grandson of John Delbridge, stated that John Delbridge was possessed of a mill in which he carried on the business of a bone manure merchant. On the 7th of March, John Delbridge endorsed upon the lease of the mill and signed the following memorandum, 7th March. This deed and all thereto belonging I give to Edward Benetto Richards from this time forth. That's the case, my lord. From this time forth, with all the stock in trade. The plaintiff was the person named in the memorandum and the grandson, and had then for some time assisted him in the business. John Delbridge, shortly after signing the memorandum, delivered the lease on his behalf to Elizabeth Ann Richards, who was the plaintiff's mother, who was still in possession thereof. John Delbridge then died, having executed several testamentary instruments which did not refer specifically to the mill, but gave the furniture effects after his wife's death to be divided among his family. The testator's widow, Elizabeth, took out administration to his estate. The bill which was filed against the defendants, Elizabeth Delbridge, that's the widow, Elizabeth Ann Richards, that's the mother, and the testator's two sons, those are the two uncles, who claimed under the said testamentary instruments. And the bill prayed a declaration that the endorsement upon the lease was or created a valid trust in favour of the plaintiff of the lease. So this was a familial dispute, because the grandson wanted the mill and everything, and the rest of the family said it was part of the estate.
It comes down to this, that if you're going to, it's going to be effective, you either convey it, in which case you do everything necessary to constitute a conveyance, or you declare yourself a trustee immediately. And the two are inconsistent. Or not necessarily inconsistent, because you can have a double-decker, one on top of the other.
You can. I'm not going to let you go, however, without reading parts of this case.
There's nothing sequential in Richards and Delbridge.
No, there's nothing sequential. No, there isn't, but there are answers to questions that are being asked of me.
Right.
And so if you turn to page 14, to 1402, the principle is a very simple one. A man may transfer his property without valuable consideration in one of two ways. He may either do such acts as amount in law to a conveyance or assignment of the property, and thus completely divest himself of the legal ownership, in which case the person who, by those acts, acquires the property takes it beneficially, or on trust, as the case may be, or the legal owner of the property may, by one or other of the modes recognised as amounting to a valid declaration of trust, just pausing there, my lord. So here, you've got to ask yourself, was recital 5 something that amounted to a valid declaration of trust?
But it wasn't, and I suppose you say the difficulty which it poses is firstly the word desires, but secondly, what is desired is that the settlement made by this deed shall take effect. In other words, a settlement where what? What does it mean, the settlement made by this deed?
Well, the settlement made by this deed is a settlement by which the children are trustees of the property. That's the settlement made by the deed. And under the terms of the deed, while she can change the trustees, she cannot appoint herself a trustee of the property. That's clause provision 6.
I mean, the settlement made by this deed it can't be the trust on which the trustees are going to hold the property. It must be something that the settlor is doing. In other words, on the face of it, transferring the trust property or intending to transfer the trust property.
No, you're going too far. Yeah. You've got to ask yourself perhaps an earlier question. Rather than ask yourself, what does this mean? It must mean X. You've got to ask yourself an anterior question. Has, by this wording, Mrs. Deslauriers declared that she holds the trust property on trust? That's the question that you have to ask yourself. In answer to my Lord Briggs, if you go down the page at 1402, about the middle of the page, the legal owner may, by one or other means recognised, etc., constitute himself a trustee without an actual transfer of the legal title, may so deal with the property as to deprive himself of the beneficial owners, and declare that he will hold it from that time forward on trust for the other person. It is true, he need not use the words, I declare myself a trustee, but he must do something which is equivalent to it, and use expressions which have that meaning. For however anxious the court may be to carry out a man's intention, it is not at liberty to construe words otherwise than according to their proper meaning, even adopting a benevolent construction. Right. And then if you go down the page, and you have two cases which are disapproved of, but in the former case, the 4 lines from the foot, Lord Romilly considered the words were the same as these, he got it wrong, which is the error I think I'm trying to avoid you falling into, my lords.
Well, yes, what Master of the Rolls is saying is that words of present gift are irretrievably inconsistent with a present declaration of yourself as trustee. And it's going back to the same point Lord Justice Turner made in Milroy and Roy, that the two were, I think he said, wholly different. But how wholly different are they?
How wholly different are they?
Yes, absolutely. How wholly different are they? If I want my grandson to have the benefit of property that I hold, why is it all that different to say, I hold it on your behalf until such time as I get round to executing the conveyance?
Absolutely no problem. That's absolutely no problem. I've said, my
Yes.
lord, already that if you go to recital 4,
Yeah.
that's exactly what she said in relation to transferring.
Mm-hmm.
I can't remember the exact words, but I transfer to my children or to the trustees to hold on trust.
Intend shortly to transfer.
Intend shortly to transfer.
Yeah. And you say that, I suppose, that...
Oh, sorry, to be held. I'm so sorry, my Lord Mance.
To be held, no, go on.
To be held by the trustees on the trust hereinafter declared.
Yeah.
Now, that's all very well. That's at, you can find that at page 226 of the electronic bundle, bundle 1. That's where the deed of settlement appears, or a version of it.
Yes.
Right. Now, it's all very well to ask me, I'm going to tell you in a minute, don't worry, what does recital 5 mean? But what recital 5 does not mean is anything analogous to what recital 4 says. And the reason is very simple. The person who drafted this, and one assumes that the person who drafted this and the person who executed it had a certain intention, necessarily. The person who drafted this knew perfectly well how to set up a trust and what the words were of setting up a trust. You hold it on trust for somebody else. Bang. You got the words holding, you got the words trustee, you got the words declared. And for your Lordship's references, I was going to take you to this case later. It's Lady Justice Arden in Shah and Shah. It's a case that is not cited by my learned friends, but they've put it into the bundles, and it's a perfectly good case. And Shah, Lady Justice Arden there specifically identified that there were no such types of wording, or rather specifically identified that in that case there were those specific words which enabled her to construe that which had occurred as a declaration of trust. Now, I'm not saying, see Richards and Delbridge, that you can't say the same in different language, but what I am saying is that if you have that language immediately available to you, and you do not deploy that language, it would be wrong for a court to infer that for some reason or other you're saying the same, but in a slightly different context. Okay. What does she say? The settlor desires that the settlement made by, she doesn't even say intends, which we all know is
Yeah.
as it were,
Well, what you say is that the one thing the settlement made by this deed can't be is a trust created where the settlor is the trustee.
yes,
Don't you?
exactly. Now, let me just, sorry, I'm aggressively addressing you.
Well, I think we are getting the
I want to
point,
make
probably.
one more point, which is very important. The settlement on the terms of the deed was explicitly only intended to take effect on the transfer of the property into the names of the trustees.
Quite.
See recital 4.
You see, there or have I got it wrong? Is there in this case the kind of words are there in this case the kind of words of present gift which there were in Richards and Delbridge? There aren't, are there?
No, there aren't. And so, recital 4 is not a settlement to the children other than in their capacity as trustees. It's not a settlement to the children as an outright gift.
Yes.
Well, it's just a fairly straightforward life with reversion settlement, life for mother and reversion for children.
Indeed, but it's not an outright gift to the children. It's not, I'm giving, exactly.
Yeah.
It's not, I'm giving the property to you.
But I mean, if you was to summarise it, on such and such, she settled her property on trust for herself for life and in reversion to the children.
By being rather pedestrian, I'm not making myself clear. She could have given the property to her children as a gift.
No, she didn't do that.
She didn't do that.
Oh, that would have been entirely different.
Let us just say that a year after this settlement, she had transferred title in the property to her children. The question then arises, in what capacity do those children receive the property? Someone might say, let's say they'd fallen out with their mother. They might say, well, this was an outright gift. You simply transferred title to me. There are two answers to that, my lords. There are three answers. The first answer is that cannot occur by virtue of recital 5. Because recital 5, which is agreed to by the children, make it clear that the settlement takes effect immediately. In other words, if there is a transfer to them of the legal estate, they take that legal estate subject to the terms of the trust, not free of the terms of the trust. They cannot argue subsequently, it was a gift.
But you wouldn't need recital 5 for that. If she executes a settlement of this kind and says she's shortly going to transfer the property to her children as trustees, and then she does transfer the property, and the transfer doesn't say whether it's a beneficial transfer or just a transfer, well, they take it as trustees.
That assumes too much. I'll tell you why it assumes too much. I certainly, if this had happened the day after, it would be very difficult to say otherwise. Let's say it happened today, which is however many years, 8 years after this trust. Would you be able to say, well, it's obviously pursuant to the terms of this deed? There may be an argument by one of the children, say, or by another member of the family, Mr. Deslauriers, for whatever reason, that actually this wasn't pursuant to the deed. If your lordship goes to our paragraph, the other thing, my lord, is that in order to become a trustee or to assume the office of a trustee, it is not necessary that there should be an actual transfer of property into the trust, of which one is the putative trustee. And by this clause 5, it is clear that the children assume the office of trustees in relation to the property, such that if and when the property is ever transferred to them, it is pursuant to the terms of the trust, which have taken effect immediately. As Mr. Justice Aboud, who's gone through all this already, in Trinidad. And your lordships probably know of Mr. Justice Aboud, who's regarded as an excellent lawyer. Not sure what.
Well, we don't generally rate judges or the authority of their decisions according to some scale, so let's keep off that.
Or put it this way,
or even
what I will say is that it would be regrettable if what appears to be established law on these terms in Trinidad is reversed by the Privy Council in London now.
Well, that is a slightly more plausible submission. Where is his decision, incidentally?
His decision, my lord, if your lordship goes to bundle 1 to page 288, I was actually going to go make some more submissions, but...
So just before you get there, the answer to my question, what's recital 5 for? Your answer is it that it's there to ensure that upon the subsequent transfer of the house to the children, they take it not beneficially, but on the trusts set out in the deed that they are now executing.
Exactly so.
Okay.
And can I commend to your lordships paragraph 31 of my written case?
Probably says it rather more clearly. Thank you very much.
Well, more clearly than I have, my lord.
No, it's there, is it? Yeah.
But it is there.
Right.
Okay.
Now, Mr. Keeley...
Mr. Justice Aboud, if your lordship could please go to the 2 clauses, which, by the way, drafted by the same lawyers as those who drafted...
Yeah, we know that.
You know that?
Which tab is it in bundle 1?
It's not. It's at page 288 of the trial bundle, of the
Right.
of the main, of the...
Quite right, yes, okay.
Of the record.
Yeah, 288, yeah.
So it's in the main file at 285. Sorry. Did I say 288? I meant 285.
Right, yes. Right.
So you have 2 persons who each own 20,000 shares in their company. They attended the offices of their attorneys, signed 2 identical deeds prepared by an expert commercial lawyer in the firm, made for provision, including their shares. The claimants, who are siblings of the defendant, claim that by the deeds of settlement, De Paul and Poplin constituted themselves as trustees of the shares, and that from the date of their execution, the shares were held by them in favour of the beneficiaries named in the deeds. The claimants are 3 of the named beneficiaries. The claimants say that the beneficial interest in the shares passed to the beneficiaries and that De Paul and Poplin were thereafter unable to dispose of the shares in any other manner than that set out in the deeds of settlement. Moreover, they say that if De Paul and Poplin purported to deal with or distribute the shares otherwise in accordance with the terms of the settlement, the transferee would take the shares on constructive trust. Then you have the deeds of settlement, the identical recitals 3 and 4, the top of page 287, which are 4 and 5 in ours. Then if your lordships could go to page, to paragraph 28, to paragraph 28 at page 296. The trusts of the 2 deeds failed because the settlors did not in their lifetimes transfer the shares in the company to the original trustee or the replacement trustees. No reason has been advanced, my lord. And before you go there, my lord, or rather before you go on, just bear in mind in the preceding paragraphs, the learned judge was taken through all the relevant cases,
Yes, right.
including Shah and Shah, including Pennington, etc. Milroy and Lord. And then the question is asked at 29. And then the learned judge says, a first point to note is that there is no question of an outright gift. And for your lordship's notes, if you ever have the inclination. Quite a lot of this is set out in our case, my lords, at pages 17 and following, paragraphs 38 and following in our case.
Now, Mr. Keeley, bear in mind the time.
I'm bearing that in mind, yes.
How much more have you got? Quite a lot more to deal with.
A little bit more on this topic to deal with.
Well, you've got some other topics to deal with, and you've got to leave
Yes.
time for a reply before the
Yes.
adjournment.
Right. Well, then if you could have a look at...
Which is when the case is due to finish.
Yes, I know.
Will finish.
If your lordships could read paragraphs 31 and 32, well, 31 through to 33 are the most important paragraphs of Mr. Justice Adam's judgment. And 34.
Yeah. Right.
Is there an equivalent to clause 9 in that deed, in this
Yes.
deed? Thank you. What's the date of this decision, or its publication?
2014, isn't it?
January 2014.
Yeah.
As a matter of interest, I mean, this is one of these trusts, the settlements that even if it had taken effect, it could be revoked, couldn't it?
Yes, good.
So there's Privy Council authority that one can actually address that situation. That's irrelevant at the present purpose. It does make it a slightly curious trust, though.
Yes. I know that one can do things like appoint a receiver and things like that, if necessary in due course. But...
yeah. Anyway, I think we must move on.
I'm sorry, my lords.
The next point is one we should probably go to, namely, what is the position in terms of priorities?
Yes. Can I just emphasise, really, do I have to dash that point? Can I just emphasise one thing, my lords? Recital 5, which is obviously troubling one or more of you, I hope only one, is, or maybe two, I don't mind if there are only two of you. But anyway, Recital 5 talks about the terms of this deed taking effect immediately. Sorry, I've just lost
The settlement.
the terms of this settlement taking effect immediately. If she's a bare trustee, that doesn't happen. It's not the terms of this settlement.
Right. Well, I think we've got these points.
Right. Okay.
Yeah.
Okay. Can I just, however, deal with one thing before I move on? Constructive trust. My learned friend Mr. Benjamin referred to the re-rose principle. The re-rose principle is one by which the putative donor does everything within his power which is necessary to effect the transfer of the legal title.
And that didn't happen here.
Exactly.
Yeah.
We're not in re-rose
Get home
territory.
in this case by re-rose.
Exactly. We're not in re-rose territory.
No.
We're not in Pennington territory, according to the majority, because that is a case analysed by my Lord, Lord Briggs, and indeed by others, as a case of detrimental reliance, where there the person concerned, the putative transferee had assumed the obligations and burdens of a director. And that is not only in the case, the Pulbrook case, of which my Lord, where my Lord, Lord Briggs was the judge, but it's also in, I think it is, I'm going to give your lordships the reference, give me a second. It's in, is it? Yes, if your lordships could go to, I think it is Mr. McGee's article at, I'm not going to take you, to Divider 35.
Right, well, we'll read that. Right, now,
and in Snell's equity. Right,
I think
I'm moving on.
I think we must set some time limits.
Right, I'm moving on.
Mr. Knox, you indented for an hour.
Why? Oh,
You did, but how long are you actually going to need? I suspect you won't need that.
Well, but you say my friend Mr. Benjamin and myself.
Yes, quite.
I don't think we'll need an hour. I would have thought more like 40 minutes.
Half an hour? Or... Right.
I'll take
Well,
it.
well, Mr. Keeley on that basis has to finish by 20 past.
Right, okay. Issue 2. This is a narrow issue, answered partly by my Lord Briggs's questions yesterday. Assuming the deed to be a declaration of trust, it's common ground that section 16(1), which you'll find in the authorities Bible, applies to it. 16(1) of the Registration of Deeds Act, Rocker, applies to it.
Right.
The Deslauriers argue, or rather they accept, that non-registration of the deed might mean that the registered judgment takes in priority to it, but they argue that whether or not it does depends upon the competing equities of the case. See paragraph 14, subparagraph 3 of their case. You cannot understand section 16 without appreciating, by reference to sections 5 to 8 of the Remedies of Creditors Act, that the effect of a registered judgment against a judgment debtor is that, 1, it operates as a charge on all the lands to which the judgment debtor is entitled or of which the judgment debtor is seized or possessed. And 2, the judgment creditor is entitled to all the remedies in equity against the lands charged, as though the judgment debtor had charged the lands with the amount of the judgment debt. Section 16 is clear in our submission as a matter of interpretation. Any competition between a deed affecting the legal and equitable interests in the lands, such as the deed in this case, assuming it to be a declaration of trust, and 2, a registered judgment against the person so conveying such land, such as Mrs. Deslauriers in this case, is to be determined according to the priority of time of registration.
For that purpose, do you read in or judgment after every such deed?
In 16.2.
In 16.1.
In 16(1) shall be good and effectual both in law.
No, when it says, it says every deed shall be duly registered, be good and effectual in law and equity according to the priority of time of registering it. So if things are effective equities created by deed, then priority takes place in accordance with the order of registration.
Yes.
It doesn't in terms say and judgment, although it refers to judgment creditors at the end of the section.
That's exactly the point. That's exactly, according to priority of registering, according to the right title of the person conveying such, against all creditors by judgment of the same person. The importance, my lord, is according to the priority of the time.
Well, I understand that. All I'm asking is, do you get to your go by adding in the words or judgment after and every such deed in line 3 and such deed in line 5?
I do, but I don't have to.
Okay.
Is what I'm saying. My primary case is I don't have to.
No, do you have to add the words or judgment? Aren't you saying every such deed should be good and effectual at law and equity according to the priority of registering such deed, as against a judgment.
That's what I'm saying. That's what I'm saying.
So
I don't have to say...
This is just one half of the comparison. The latter half is
It's just the competing.
further down.
It's what is their competition.
Yeah.
And then when there's a competition, then what is good and effectual is according to the priority of time. You know, the judgment was registered on the 25th of October 2011. The deed's never been registered even to date. Judgment takes priority over the deed and any declaration of trust in it. If you go for what my learned friends suggest, which is that you have to work out what the competing equities are, then you are simply descending into what the Court of Appeal thought was appalling, which is just total uncertainty. Because you'll never know what the priorities are until someone has determined what the equities are in that rather nebulous approach which is being proposed. And the Court of Appeal was saying that any contrary construction or interpretation was a recipe for uncertainty. What people want to know when they either have a judgment or when they buy something, or whatever it is what the encumbrances are or are not in relation to the property with which they're concerned. So judgment creditors who register their judgments need to know whether there are existing charges or encumbrances on the property. And if a judgment creditor, as in my case, my lord, is going to say, right, well, I'm going to execute, it's going to send someone, which we did, to have a look at the registration of title and all registration and find nothing, and then up pops Mrs. Deslauriers with what she says is a declaration of trust, then that is a recipe, as I've said, for uncertainty and ignorance, which is ridiculous.
I wonder what subsection 2 actually adds.
Well, subsection 2 does add something, my lord. It's like the question, what does recital 5 add? Subsection 2, my lord, adds this. This says that a deed which isn't registered is fraudulent and void as to those lands against any subsequent purchaser for value. So,
whose conveyance shall first be registered?
Whose conveyance shall...
But if his conveyance is first registered, it would take priority anyway under 16.1.
Yes, but then you've got a registration of... Then you've got a registration of the deed, and then you've got that person, the purchaser for value without notice, who wants to sell on. And that buyer says, but there's something registered now. And so the seller, who is the purchaser for value without notice, has to say, don't worry about that. That is null and void and can't affect you. Whereas, my lords, if it were simply a question of priorities as opposed to nullness, as it were, nullity and voidness, that argument may not be so robust. Because the subsequent purchaser may say, well, in terms of priorities, if you look at 16.1, my lord, in terms of priorities, your purchase takes priority over the registration of the deed, or whatever it happens to be, but it's now been registered subsequent to your registration, and how does that affect me when I want to buy from you? So you have property A, over which there is a deed. There is also a judgment creditor who has a registered judgment. The deed is registered the deed is not registered and someone buys the property without notice. You've got a clear title. The deed is then registered. The person who's bought the title wants to sell it. The buyer says, but look, there's something on the register. And the purchaser for value says, null and void, illegal. And so the sub-purchaser says, phew, I can buy it. Whereas if 16.1 only applied, there would be an argument that whilst the deed might not be effectual in law, as against the purchaser for value, it could well be effectual in law as against the sub-purchaser.
And you presumably say there's no need to add judgment creditors there, because if the effect of the judgment is to create a charge, you simply have a prior charge.
Exactly.
Ignore the subsequent charge in terms of paying yourself back.
Exactly.
Or you might have to pay the subsequent charge any surplus.
Exactly so, yes. So I'm sorry to have rushed that one, but that's quite a difficult 16.2. Is you just have to work it out.
Is that in your skeleton? Sorry, your case somewhere?
No.
That point?
It's the sub-purchaser's protection you say that 16.2 is for.
Exactly. The
Okay.
onward, yes.
Got it.
Yes, that's right. Right, so that's 16.2, my lord. Issue 3, discretion. There's just one point I've got to deal with in issue 2. It's been raised that I shouldn't be entitled to raise issue 2, with which I've just dealt.
Because you didn't expressly rely on Section 5, etc.
Because it was only dealt with in the Court of Appeal and not at first instance. There was no demur to it being dealt with in the Court of Appeal. It's a question of law. It's been dealt with. That's it. Issue 3. If you could go, please, to the relevant act, which on this occasion is the Remedy of Creditors Act. My learned friends have two arguments, as I understand it. Firstly, that there is a discretion we're talking now about Hebron Heights. We've moved over, as it were, to Hebron Heights.
No, we haven't.
No, we haven't.
No, we haven't.
Still
Sorry.
Victoria Square.
Work it out where
They're
I
on the
am.
home, the ancestral home.
It's still the summons to sell Victoria Square.
Yeah.
You're absolutely right. Forgive me. Yes, I've got confused with my appeals. Not my appeals, my resistance to the appeals. We're still in Victoria Square. My own friends say that there is a discretion under sections 37 and or 38 not to order the sale. The terms, my lord, of section 38 are mandatory. Subject to the satisfaction of the preconditions, a declaration shall be made accordingly. There shall be a declaration accordingly, and the same, that is to say, the sale shall be ordered.
Yeah.
If you want to see where the Act actually confers a discretion, then by all means have a look, for example, at sections 46 and 47, page 1025. And then you can see where, when the Act wants to confer a discretion, it confers a discretion. There are other sections. I've just chosen, as it were, the closest neighbours I could find. 46, 47, 48, 50. These are all words or tenses of verbs.
So how does section 54 work?
54 is a case which applies.
Well, that's another example of a discretion, and it actually relates directly to back to 34, doesn't it? 37, rather. If it doesn't appear desirable that the asset, it fortifies, in other words, your case on the mandatory nature of the earlier section.
Yes, but it's also used against me because it's suggested.
38, yeah.
It's used against me because it said that out with section 38, there is, however, a discretion.
Yes, of course. Well, it is. That's what we've got to consider. The question is whether you have a notional break. Is it after, in about the 7th line, after the words "the execution debtor," and so that. Oh no, perhaps no. In the 4th line, after the words "till further order."
Yes.
Yes.
Where there is
And
a comma.
yes.
Yes.
Whether they're separate or whether it's only if you go on to do one of the things by way of awarding equitable execution, etc., that you can order a stay.
That's absolutely right, my lord. Our submissions are at paragraph 66 and following. And we remind you at footnote 93 that you should look at the headings and the margin notes, since they provide useful or can provide useful guidance in the interpretation of statutory provisions. as the Montilla case and Benyon on statutory interpretation. Of course, the margin note here doesn't answer the question perfectly, but it says sale may be stayed and receiver appointed.
Is the marginal note 38 of any significance?
That is not helpful. That just shows, my lord, that
That's how dangerous they are.
that when Montilla says that they can be helpful, they're not necessarily always helpful.
Well, I suppose the may in the marginal note reflects the fact that it has to be proved to the satisfaction of the judge, etc., etc.
That is the clear answer that I was proposing to provide.
All right. Well, now it'd be rather odd if, I suppose you say, if it was just an unqualified permission to order a further execution to be stayed till further order, but
Well,
and it's perfectly natural, I suppose, to say that if you're going to stay, well, why at least shouldn't the creditor get the benefit of any income coming from the property? So why aren't, it's perfectly logical to link a requirement of extra execution to a stay. The alternative is that it'd be odd if there's no discretion to cater for exceptional circumstances.
it's not odd, actually. When you have an order, the general principle, my lord, is as expressed in our case at 65 subsection 7. It's only a general principle, so...
Did you get your money? Is that right?
Well, it is Lord Brandon in Roberts and Petroleum
Yes.
saying a judgment creditor is in general entitled to enforce a money judgment which he's lawfully obtained against judgment by all or any of the means of execution prescribed by the relevant court's rules.
Well, you may say it goes further than that, because the judgment creditor in Trinidad and Tobago is quoad any land of the judgment debtor, an equitable chargee with power of sale.
Yes.
So to
But even
deprive
an
him.
equitable chargee of power of sale may be subject to an application for a temporary stay, for example, to give the debtor time to redeem.
In relation to that property. In relation to that property. But your lordship's absolutely right. What is odd about this case is that what is being proposed is that there should be a stay of the sale of Victoria Square when there's a mortgage and a judgment in respect of Hebron Heights. So the stay is not actually, as it were...
To redeem on.
Exactly.
No.
It's not.
Well, save only that it said that if you sell Hebron Heights, that will actually pay the debt, so you won't owe anything. We won't owe anything under the charge of Victoria Square.
That's a debate that we can have for
Yes.
just about ever.
Yes, but we've got to test it, haven't we, by reference to the case, which may very well not be this case, where the judgment creditor is, through Section 5 of the Remedies of Creditors Act, a chargee of all the pictures in the judgment debtor's gallery. But the Gainsborough, which everybody agrees is the right picture, or is it a Reynolds? I can never remember.
This is Reynolds.
Reynolds, the Reynolds, which everybody agrees is worth 5 million, more than extinguishes the debt, which is, shall we say, 1 million.
Yes. I see the argument, my lord. My answer is that this section is about...
I know, in this case. Yes.
This section is about realising the value of the property other than by sale, but executing upon the property with the appointment of a receiver so that the judgment creditor, in our case, has the rents. So it might be said, don't sell Hebron Heights, forgive me, don't sell Victoria Square, but rather appoint a receiver and have all the rents paid to the judgment creditor. Now, that's a perfectly legitimate approach to the interpretation of this section, which is that I endorse as a matter of submission.
Sorry, just repeat the interpretation that you endorse.
You stay the sale in order to have equitable execution
Right.
via receiver. That's the whole idea of it.
But you're not entirely, I mean, even the passages dealing with equitable execution, etc., don't appear to completely to exclude discretion. If you look at the last 4 lines, it can be appoint a receiver of the entire rents and profits of the said land, or of any part thereof. And then the last thing, order any person in receipt of the rents and profits to pay into court the whole or such proportion thereof shall be directed for such time, or to such amount as shall be just.
That's because those monies have, as it were, already gone. So it's not a question that you see there, order any person in receipt of them, rather than the receiver who actually, as a matter or a mode of execution, equitable execution, takes receipt of them. So that is what happens there, my lord, is where the receiver has not been able, doesn't get them for whatever reason, and therefore it's another mode of execution upon the rents that the receiver would otherwise have received.
You're tracing them into somebody else's hands.
Exactly, yes.
But you don't have to appoint a receiver of the entire rents and profits, entire rents and profits, or any part thereof.
Well, the reason is obvious. If you, well, let me just postulate an obvious answer. If you've got a judgment for 5 million, and the property is worth 30 million, and the rents are 2.5 million per month, you're not going to order the sale. You're going to say,
Exactly.
have the rents.
Yeah.
All right, yes.
But that's not this case.
Yep.
So-
So you say any stay is linked to one of these consequential orders?
Yes.
Which I suppose the court could have made in this case. It could have stayed, but I expect Mr. Knox will be happy to fall back on that. It would avoid a sale.
I don't think so, because according to Mrs. Deslauriers' evidence, she relies upon the rents of this property in order to...
Well, to keep up Heaven Heights.
I believe so, yes.
Well, maybe she'd, rather than lose her home, perhaps she'd prefer to have a stay and forego the rents.
Yes. Before your lordship weeps too much, we're talking about a penthouse apartment in an otherwise commercial rental property. The bottom 3, the basement and the first 3 floors are rented out, and there's a penthouse. And also Goodwood Park, according to Mrs. Deslauriers' evidence, has, I think it is 6, maybe 5 apartments, of which only 2 are occupied currently by her family. So, and your lordship shouldn't think that we are a hard-nosed, unpleasant financial institution. We have shareholders like anybody else, and we would like actually to be repaid our money.
And the sale is anyway going to be subject to the leases, isn't it, except for hers, presumably?
Yes.
Yeah.
And don't forget that our money paid off her loan from Republic Bank in relation to doing up Victoria Square.
Yeah.
I mean, I know it's not a sort of a great legal point,
Yes. No, well, we've got...
Yeah, we've had it.
but we have funded
Yeah.
Yep.
her for the last however many years.
Right, 4 minutes to go. What other points?
Right. Other points? Oh, well, yes, next point. If you do have a discretion,
Yes.
and you're going to start
Yes.
thinking about valuations, I'm as good, well, I'm not. I will be as good as anybody in fiddling around with these figures. Your lordships should bear in mind, in relation to Hebron Heights, it has been empty. Well, it's never, ever been full, but it's been undeveloped in any respect since 2009. It's all very well for Mrs. Deslauriers to say, oh, well, she's been, got security guards and it's absolutely perfect. You know perfectly well in the Caribbean, exposed to all the elements, that things deteriorate. It's no surprise, my lord, that Mrs. Deslauriers has made no real attempt to sell this property, or if she has, that she hasn't managed to do so.
Well, that's surely the principal point, isn't it, on discretion? I mean, if it were so obvious that Hebron Heights was saleable and should produce the money, she'd have sold it by now.
Yes, she would have done. She would have done. And she said in 2012, look at paragraph 73, subparagraph 3 of ours. And I say this without intending to be excessively rude about Mrs. Deslauriers. You've got to bear in mind that her affidavits are, as it were, elastic. When she wants the property value to be low, she says the property value is low. When she wants the property value to be high, she seems to produce something which would suggest that the property value is high. In 2012, my lord, she said that Hebron Heights would fetch about $20 million or maybe less. She produces, and I'm going to go through these figures only so that you know that I've done my maths. She then produces a valuation which provides a valuation of $77,235,000. I know this is going to bore you. It's done by reference to the residual.
Right.
Right. Okay.
Well, wait a minute. It's done by on the basis, I think Mr. Knox told us, of the money spent on it originally, and then isn't that right?
I think this is supposed to be the value of the property if sold as a fully developed property.
Yes, but calculated by reference to the cost of, in part at least.
Yes.
It's a residual valuation.
Yeah.
Exactly. But what you're doing is you're projecting forward.
Yeah.
So if this property is completed in 3 years' time,
Yes.
we estimate it will realise $77 million.
Right.
So there are a number of components there that you've got to take into account, a number of important components. The residual land value method is a projected amount. So you've got to discount for net present value, which is usually, I'm giving evidence, but you'll know from your own experience, whether you're talking in any financial area, it's somewhere between 7 and 10% per annum. So if you're talking about 3 years, you're into the 20% mark. Secondly, the evidence, if you look at footnote 108, that's all you need to look at for present purposes, apart from what I've just said. Footnote 108, the costs, and this is really quite staggering, the costs of completing this project are $48 million plus.
Yeah.
The person who's going to buy this property, in order to develop it, will want to make his profit, which is in the land market anywhere between 20 and 30% for any developer. Mrs. Deslauriers will no doubt know that very well. This cost, or this value, takes no account, and therefore I shall take no account other than to mention it, of the sales deposits that have been already made by prospective purchasers of these apartments, who are no doubt terribly disappointed, of some $35.4 million. So this is vacant possession. But if Mrs. Deslauriers is going to sell this property, she's going to have to pay back these depositors if they don't already have some equitable interest in the property anyway. No doubt unregistered, but we can not worry about that today.
Well, the figure for depositors was 30?
35.
35 million, yeah.
35.4.
Yeah. Right.
The best offer that she has apparently had, which was not a committed offer, was 54 million. She produced this valuation in order to seek to persuade the prospective purchaser to up his ante. And he turned it down and, in fact, disappeared. He is no longer a viable proposition. So she doesn't have anyone for this property.
Yeah.
And you can imagine if my clients, the bank, were to take it over and assume the burden, which is not within their expertise, and have all the problems with the depositors, no doubt claiming some form of priority. No doubt Mrs. Deslauriers would sue us for selling at an undervalue. She's already complaining about the fact that we have undervalued, or we rely upon an undervaluation
Right,
of
but
Victoria
I think-
Square. Right, I'm done.
Yep.
Is there anything else? Let me see if there's another issue that I've missed out. Reserve price, discretion of judge. Period.
Right.
Any other questions?
Thank you very much.
Lords?
Mr. Keeling? No.
No.
Ms. Lindsay?
No, thank you.
Yes, Mr. Knox.
My Lords, can I just make a preliminary point? My learned friend spoke about the ownership of various properties by Mrs. Deslauriers, and litigation should be involved. And I would like to make some important corrections. It was suggested, I think, by my learned friend that she owns 5 Goodwood Park properties. She doesn't. It's 2. Those were the subject of the potential security for the loan in question. It was also suggested that she was involved in litigation with the Republic Bank and her stepbrother in cases involving fraud. Well, I think I'd like to clarify that. She was the victim of the fraud. And the notion was put across that somehow Mrs. Deslauriers just loves litigation. And when she wants to get lawyers, she gets them involved, and when she doesn't, she doesn't. Well, my lords, suffice it to say, at the moment we are appearing without fee, and that has been the case in other bits of litigation. So this is not a case, as it were, of a very rich woman who chooses her cases carefully, which ones to fight. My learned friend said that our whole case was premised on a promise to finance the Heffron Heights project. I've made my submissions on that already, but I would just like to emphasize this. It is important to note there was no allegation of an express promise pre the loan by Mrs. Deslauriers either in pleadings or in the witness statement, in her witness statement. That wasn't her case. Likewise, there was no allegation that even afterwards there was an express promise until, she said, in November there were off-the-record conversations with Mr. Ramdeen when Mr. Ramdeen said he'd like to help her finance the rest of the project. So in other words, it's important to note that what you might call the express promise case was never, in fact, a wholly different case from the case we're now running. It may have been an exaggeration, a legal exaggeration of the facts, but the basic facts we're running have always been there. I accept that some part of her evidence was rejected. That doesn't follow that all her evidence or all her case is to be rejected. But I do submit it's a fallacy. Of course, it's one that advocates are always wary of, to suppose that because one case, your best case, is rejected, it follows you haven't got a case on the other. And I submit that is the important thing for the board to focus on in this case, our current case. And I respectfully submit it is plain from the pleadings I took you to yesterday that the case, our case on non-disclosure, both on the facts and on reliance and loss, was not dependent upon an allegation that there was a promise to finance or even that GAM said it wanted to finance the whole project. It's a self-standing allegation. And it's sufficient in my submission that before the contract, that Mrs. Deslauriers made it plain that she might require further assistance. You've actually got it there in writing. A point which goes entirely uncontradicted or without comment. In my submission, once it was known to GAM she might require further assistance beyond the immediate loan she was seeking, the obligation arose upon it, in a conversation about discussions about differences, to say, by the way, you've said you might want further assistance. That is another difference between us and a bank. We won't be able to give you that, or we doubt we'll be able to give you that. Once it was known she might want further assistance, at that point, GAM had to say, I don't think I can give you that. We're not like banks in that respect. And likewise, I submit post-contract, and I say post-loan, it is sufficient that she made it plain that she was looking to them as a possible source of funds, as unquestionably, further funds, as she unquestionably did in July 2008. I took you to the email. I think it's 141 of the record, which contains a clear request for financing. Would you like to finance, or would you like me to pay you down? Now, as far as intention to induce is concerned, my learned friend referred you to the judgment of Lord Justice Ricks in the Avon case. I don't propose to go there. I accept the inducement must be a substantial inducement. But on the facts of this case, whichever version you look at of the representation about the difference between banks and GAM, it is plain it was that conversation took place in a context where it would be, just looked at objectively, a substantial inducement. And I took you yesterday to the relative passages of Mrs. Deslauriers, page 197, paragraph 11, and then 199, 16, para 16. The latter in particular was a question that was asked just before signing the contract. In Mr. Ramdean's case, it's paragraph 36K, page 79, where he says this conversation took place in the context of a discussion about whether the Deslauriers should take their business together. So these aren't just sort of off-the-cuff conversations. The context of the conversations is on any footing in my submission sufficient to make that a material representation. The question then is it false? If I can go next to the question of reliance, my learned friend took you to the Anand point, which is in the cross-examination of Mr. Deslauriers at page 414. And she says, what the heck did Anand mean by that? And he therefore says, well, you should approach the entirety of her witness statement with caution, in particular paragraph 13, where she speaks of reliance. Well, one sees the point, but only up to a point. This point about the lending limits being important was a point that was repeatedly drummed by Mrs. Deslauriers well before the pleadings and the witness statement. Indeed, if I can just ask you to go back to page 167 of the record, this is what Mrs. Deslauriers says in answer when she's told, finally, that there's going to be no further financing. Her immediate reaction, over the weekend, I suppose, is to complain that she hadn't been told of the limitations in funding. So the suggestion that somehow this sort of is a cooked-up case, I submit, is plainly wrong. That's say cooked up with the assistance of lawyers, is plainly wrong. It was her immediate and own reaction. And indeed, yesterday I took you to the other correspondence where this is the one thing she goes on about most, about you didn't tell me that you couldn't finance the rest of it. And just for your record, my lords, her emails of the 23rd of April 2009 at page 169 to 70, and of the 11th of May 2009 at page 176. So the attack as well, her witness statement on reliance, I submit, is not a good one. The second attack on the question of reliance is that the judge has rejected some of her evidence about some of the events that took place, which she said were combining factors towards the reliance. And he took you to paragraph 13 of her witness statement. Perhaps I can briefly go there. Sorry, it's at page 198.
Yeah.
And she essentially identifies two things. Based on the understanding, the claimant's representative indicated that the only difference between the claimant and a bank is payoff couldn't be done before 1 year, that they didn't indicate any limitation on their lending capability, we count that as one, and that we would be returning for funding at the completion of the construction phase. We agreed to move our business. But, my lord, supposing for the moment one just removes entirely, and that we were returning for funding at the completion of the construction phase. My lord, there's no reason why the whole case in reliance just falls away because there was, let's say, no actual discussion to the effect that they would return for funding later on. If the position is she'd made it plain anyway, they might want further financing, that's it. I mean, in other words, just because you dismiss, I say I rely on A and B, the court says, well, I don't really believe you relied on B, it doesn't mean I didn't rely on A.
No, it doesn't mean you did.
Not necessarily, but my lords, one then has to assess the point. And my lord, the great problem in this case, she wasn't challenged on this. It wasn't put to her, look, what did you really rely on? You couldn't have cared less about those limits. You didn't think any further financing was ever going to come to you, did you? Nothing like that was put to her. And what I do submit comes across from her own correspondence. Take, for instance, the July 2008 email, where she says, what if I pay you 8 million? Can you then give me 10 million? What's the position on that? She plainly thought that they were able to give further finance if she wanted it. And indeed, why wouldn't you think that if you've had email correspondence in which you've said, I might want further financing? So I submit on reliance, it's not a good point on the facts. When you look at the other correspondence, essentially, my lords, my case on reliance turns not so much on oral evidence, but just looking at the emails you have in June 2007 and July 2008. What's in her mind? It's obviously in her mind that she might want further finance. That, I submit, is the trigger, which makes it imperative that the bank tells her, you're not going to get it. You're unlikely to get it. My learned friend referred you to paragraph 75 and 76 of his case. If I can just very briefly deal with those. First, he says there's no reliance because the lending limits were irrelevant. Well, if that's right, there's no misrepresentation. So it's a non-point, if I can put it that way. The premise of my case on reliance is that there was a misrepresentation because the lending limits were relevant. The second point my learned friend takes is the judge's finding that Mrs. Deslauriers told GAM that she was sourcing financing elsewhere. And that's at page 434, para 52. And he also found, on the back of that she was not relying, or the Deslauriers were not relying on GAM initially for further financing. That's para 52, page 434. Now, my lords, I've made my criticism of that in other areas. Can I just sort of put them all in one go? First of all, I say the judge's finding that Mrs. Deslauriers told Mr. Ramdeen that she was sourcing from elsewhere was, first of all, ignores the June 2007 emails. And she plainly is not saying there, don't worry, I'm going to get everything else from somewhere else. She's actually saying the opposite. I might want to come back to you later. But of course, the way I'm planning to do it is getting money coming in from the purchasers. But, if necessary, I might have to come back to you. Secondly, the judge's finding that Mr. Deslauriers was relying initially, and that wasn't relying initially for further financing on GAM, is premised on a misreading, as I suggested yesterday, of Mr. Ramdeen's evidence. His evidence was simply that she said it was her intention to seek further funds elsewhere. And in my submission, in context, there's a big difference between saying, well, my intention is to get the funds elsewhere, which basically means, of course, I might still want to get them from you if necessary. That's one thing. But it's another thing to say, no, don't worry, I'm getting them from elsewhere, which obviously cuts out entirely the possibility of asking GAM. So I submit that finding is wrong, and one's entitled at this stage it is wrong, but it simply goes further than the evidence. It might not look much further, but in context it's an important difference. Again, on reliance, my learned friend suggests that the email correspondence of July 2008 and November 2008 destroys the case on reliance. My lords, I make 2 points. First, if I may deal with the July 2008 email, which I think one sees at 139. If I can just go to that. She's asking for the letter with the total payoff. If you prefer I not pay it off as the project's continuing, I have some questions. And then she asks the questions about paying down 8 and then taking out 10 later. And then she continues, if I pay off the entire amount, and Dan's clear, do you want to finance the balance of the project? And can I still pay off? So she's plainly saying that the rest of the project is to be financed. How would it work, essentially? And then she continues, I have to start thinking ahead and would like to know if you want to continue with the financing of the rest of the project, or should I just look to paying it in October? Now, and she then talks about the differences of the bank, and you've got your 75% limit. Can I keep drawing? Now, my lords, what I submit that shows is it supports our case on reliance. Indeed, it's a very important email, because what it shows, I accept it's post-contract, I'll come to that in a moment. What I say it shows is that on the one hand, in GAM's favour, it shows a realisation on her part that there's no mutual commitment between herself and GAM, that she will borrow from GAM and GAM will lend to her more than they have. It obviously knocks out a case in what you might call contract, that both parties have bound themselves to give and to ask for further financing. But on the other hand, what it most certainly does do is it shows that she believed GAM could give further finance, and indeed it was something which could seriously happen. And indeed that she was entitled to up to 75% of whatever the value was at the time. And she's plainly assuming she's going to be able to get another 2 million or whatever, or GAM can give another 2 million. Now, I submit it is, you've already had my submissions on this anyway. At this point, at the very latest, GAM sort of said, well, I should let you know. I know I told you earlier about being different from a bank and all the rest of it. I should let you know this is another difference between us. But in any event, this does not destroy a case on reliance at all, not the case on reliance we now make. As far as the November email is concerned, it's at page 229. It's the second on the page. In answer to Mr. Ramdeen's request at the foot, Mr. Ramdeen's email at the foot of the page, he says I'd have to extend the existing facility out, and so on. Mr. Deslauriers replies, I can understand the additional one. I can't see why the first one. In other words, I can see why you're going to have to make a request for the extension or additional facility. But again, all this shows is that she thought there wouldn't be a problem. Now, I agree, it shows there's no binding commitment, but nothing else. But as far as my current case is, it supports it. It shows her belief. If I can put it this way, neither of the emails I've shown you demonstrate that Mrs. Deslauriers entered the contract in the first place without reference to GAM's ability to fund the rest of the project or to lend more, or that she stayed with GAM without reference to her belief in its ability to fund any further financing. My lords, my learned friend then spoke about duty of care post-contract. Now, can I just clarify? I've made this point already. We don't allege that the Misrepresentation Act helps us post-contract. Obviously not. We do say, however, the negligent misstatement having been made pre-contract, it continued to operate upon the mind of Mr. Deslauriers. And therefore, at any point, the GAM came under a duty at any point to correct that misrepresentation, and it was under continuing duty to correct that misrepresentation thereafter. Put another way, if Mrs. Deslauriers can show that she continued to rely on it, she continued to be misled by it, and acted on that basis, then she has proved reliance. So if she can say, look, post-contract, I still continued to believe you could finance, and therefore I didn't move when otherwise I would have done, then that's sufficient reliance for the purpose of a negligent misstatement claim. Now, you then have questions
which
of loss.
depends on a breach of duty.
Of course it depends on a breach of duty. Well, the breach of duty would be the negligent misstatement in the first place.
Yeah.
But yes, but all right.
So in other words, if there has been a negligent misstatement in the first place, which has operated on her mind before the contract, it doesn't become extinguished at the point of the contract.
Well, if it was one which gave rise to a duty of care.
Yes. Oh, yes. Oh, yes. Yes. I'm presupposing there was a negligent misstatement pre-contract. But if there was a negligent misstatement pre-contract, its effect, so to speak, doesn't cease upon the entry into the contract, because it continues to mislead the representee as to the future conduct after the contract. In relation to lending limits, Mr. Keeley has said, well, has made the point about there's no evidence about GAM's limits or indeed banks' limits. But, my lords, I submit it's vital to distinguish between two different things. First, what you might call the actual strict lending limit, which was imposed upon GAM and indeed banks by the 1993 Act. The actual strict lending limits per project. You've got 25% of capital per project. That is one type of lending limit. But there are also practical lending limits. And our case relates to practical lending limits. GAM was subject to practical lending limits. And the evidence for that, I'll just wrap it up if I may quickly, is the 8th of January email at page 236 to 237. Secondly, the 1st of May 2009 letter from Mr. Ramdeen at 172 to 3. And my learned friend relies upon what Mr. Ramdeen says in paragraph 26 of his witness statement at page 76, where he says that at that point that he wasn't sure that the request for an extra 6 million would be approved by the committee. My lord, that was a conversation in December 2008, paragraph 26. And what the important point is that after that, he goes and talks to the investment committee. One can see that at page 233, which in turn prompts the email of the 8th of January 2009. So in other words, his evidence at paragraph 26 precedes the 8th of January 2009 email. That's the short point. So the 8th of January 2009 email reflects GAM's own position. And that's why I say you should take the 8th of January email as what you might call the conclusive evidence on the point, or the best evidence on the point. It reflects GAM's own considered view. As far as the point about bank limits is concerned, my lords, we had this discussion yesterday, but I do repeat, it's unrealistic, bearing in mind no one has suggested below that banks were subject to some sort of limit like 1.86 million sterling in relation to financing projects. And I submit it's unrealistic to suppose that banks were subject to such a limit, nor indeed did GAM suggest as much itself, except you might say on whom is the burden of proof. But on the other hand, on the face of it, it seems so unlikely that banks would be subject to such a limit that if I submit the burden in practice was on GAM. My lords, as far as causation is concerned, my learned friend says there's no evidence that the appellants could have got finance from anywhere else. My lords, there are two questions that gives rise to. One is, could they have got the loan itself from somewhere else? The second is, could they have got a further advance from somewhere else? Now, as far as the loan itself is concerned, they already had a facility at Republic Bank. There's no reason for supposing they couldn't have stayed at Republic Bank at all. That wasn't suggested. As far as further financing is concerned, there's simply no suggestion this was a bad project. Indeed, all the evidence is it was a good project. And therefore, I submit to suppose that the inference can properly be drawn that another bank would have been prepared to finance it. And finally, questions of loss and assessment of damages. My learned friend says that the crash, if I can put it that way, in 2009 was novus actus interveniens. And this is a mere duty to inform case. Well, my lords, I have a number of suspicions on that. First of all, this is just as a matter of principle. Our case is that had correct information been given to Mrs. Deslauriers before the end of 2008, she would have been able to find another lender who would have committed itself to providing finance before 2008. So she wouldn't have found herself in the pickle she was in. My learned friend says, well, all this goes down to the drop in the market. So what? The mere fact there's a drop in the market does not mean that my client couldn't recover if she's right in principle. My lords, it's not the sort of point you could decide in the abstract, if I can put it this way, at this stage. One would have to look much more carefully at the facts. So what? The market dropped. Her position is, I wanted to be with a financier as early as possible to protect me against exactly that type of thing. And as far as assessment of damage is concerned, my learned friend says, well, it would be horrific to send the case back now, after all these years. How would the assessment be carried out? Our answer to that is, well, the fact that time has passed since the original judgment is neither here nor there. If the judge should have ordered an assessment of damages, then, my lords, that's what you should do. My lords, I shall hand over to Mr. Benjamin.
Thank you.
My Lords, I shall go at pace and ask you to forgive me in advance because of the limit of time. My Lords, can I respond by inviting my Lords simply to look or to take a note at the citation for my Lord Briggs's decision in Pulbrook. I'm relying on paragraph 47. It's at page 1157. And that says, and I'll read it out to you, you don't have to turn it up, I reached that conclusion, the conclusion he reached, without any great comfort that the existing rules about the circumstances when equity will and will not perfect an apparently imperfect gift of shares serve any clearly identifiable or rational policy objective. So what I want to suggest respectfully is that's a basis upon which my Lord should analyze the rules set out in Milroy and Lord coming forward. And I would like respectfully to advance a couple of propositions as to the construction of the settlement in light of those principles without taking you back to them. So these are principles of construction. First, one, equity will not seek officiously to defeat a gift. See the decision of the Privy Council in Choitram. It's at page 11, which you will see at page 1435 of Lord Brown-Wilkinson's judgment. See Lord Justice Arden in Pennington and Wayne at paragraph 63 of her judgment. And similarly, see Shah and Shah at paragraphs 15 and 17 of her judgment. Two, the interpretation of the words is always colored by the context. So that context can turn words which appear to be words of outright gift into that of trust, or in this case, as my fallback position, words in the recital 5 in their context as a declaration of trust. See again Lord Brown-Wilkinson at pages 10, paragraph A, and page 12, paragraphs A and paragraphs C to D. Proposition 3, that a permissible construction of the document in question as benevolent in its context does not prevent the court from construing the words in a permissible manner. See the very same references. Proposition 4, in a composite transaction, see the exchanges between my Lord Briggs and my learned friend, one can declare a gift to trust. Similarly, one can also declare oneself a trustee. See again Choitram, page 12, paragraph E. See Shah, paragraph 14. Compare Milroy and Lord, and compare for the opposite proposition, paragraph 19 of Justice Abood in the Bawani judgment, where in the very first sentence he says it can't happen in the same document. But of course it depends upon what the language of the document is. And then the last proposition is that where there are clear words on the face of the document, and I think I'd be going a little bit too far to say this proposition applies to me, but where there are clear words on the face of the document, there is no need to resort to the principle of benevolent construction. See Shah paragraphs 20, 22, and 24. So, my lords, we say respectfully that the settlement clearly discloses a life interest in favor of Mrs. Deslauriers, applying those propositions with a reversion with respect to her children. My lord, that's all I wish to say about the trust issue. Can I turn now to the issue of registration? My lords, in this case, there is a clear contest, or competition, to use my friend Mr. Keeley's words, between not two parties, i.e., it's not a competition between Mrs. Deslauriers and GAM. It's a three-party competition. It's a competition between Mrs. Deslauriers and her children and GAM. If you accept my argument in relation to the trust, And we have a situation here where neither of those two individuals were parties to the summons for sale, and they ought properly to have been, so that a decision adverse to them, or adverse to their interest, as argued for, as reflected in the deed of settlement, would be one in which they would not have been heard, and that would not be a right way for the court to proceed.
Was that point taken before?
Yes, it was. The reference I can give you is page 538. It's an affidavit of Mr. Faris Al-Wari, and he says, he's summarizing the points that were taken before the learned judge at paragraph 18, because there was no transcript of those proceedings. So if you go to that affidavit, it was filed on the 26th of January 2015, and he has, according to his note, so it's 537 and 538 of volume 2 of the Record of Appeal in Victoria Square. And I'm on point, Roman numeral number 6. And what he says with the points taken before Justice Rahim was that there was a lack of notice of the application. I'm reading, my lords. A lack of notice of the application with respect to the Victoria Square property, as the tenant and the beneficiaries of the Deslauriers Trust had not been served or heard from, and the requirement of notice being given to persons to be affected by the order for possession and sale. So what, of course, his lordship, what that is reflecting, I think it's sections 31 and 32 of the Remedies of Creditors Act, where there is a provision for giving notice to individuals who have a competing interest.
I think I've misheard your page reference.
Sorry, my lords, I'm on 538.
Yes.
And does my lord see it does begin with the words development and the Victoria Square property?
So which paragraph?
So it's Roman numeral 6. Lack of notice.
7 lines down.
18, little Roman 6.
Okay. Oh, I see.
Obliged, my lord. I'm sorry. I'm so sorry if I gave it too quickly. And then that brings us to...
So this was a submission made in the Court of Appeal. Did the Court of Appeal deal with it?
No,
I mean, it has to be...
that was...
It seems very unlikely.
My lord, I don't want to mislead anybody. I'm trying to be accurate. What he's saying there is that was a submission, a point taken before Justice Rahim. So what he's doing, if you look at paragraph 18, what Mr. Faris Al-Wari is deposing to is that Mr. Mendez advanced submissions on the need to.
Oh, yes.
Yes.
They've had plenty of...
And I did adopt that submission.
I mean, they must know about this.
To answer my lord's question, I adopted that submission for the purpose of the Court of Appeal. I'm sorry, my lord Briggs.
Yes, they
Well,
must.
surely the children have known about this application for sale and had buckets of time in which to apply to intervene.
My lord, I couldn't say yea or nay. It sounds a sensible observation. They're not my clients. I simply do not know. I couldn't answer.
Well, it seems inconceivable that... anyway, there we are.
Well, my lord, my point is much simpler. Whether they knew or not, with respect, is not to the point. The section provides a power to the judgment creditor to bring it to their attention, and it's a question of whether or not that was done. I'm not going any further than that.
Has any court, was it pursued in the Court of Appeal, and has it been dealt with there at this point?
I drew it to the Court of Appeal's attention. I don't think it was referred to in the judgment, but I can...
Is it in your submissions?
It's not in the judgment. It's not in the judgment, which is to be found at pages 735 and onwards of the Record of Appeal. My lords, can I just make my 2 quick points about on the provisions of the Act, Section 38 and Section 54? So, first of all, I say, as you would expect me to say, that the marginal note is in my favor. But I say further, going to the substance of the section and read it in its context, what I say about the Remedies of Creditors Act is as follows, which is that it's not simply a discretion. My argument is not simply that there's a discretion as to whether or not a sale could be ordered. I mean, I get the argument against me that it must be mandatory if conditions are met or set out. My argument relies upon the discretion which the judge must have as to conditions, and therefore my argument is about conditions and timing.
It's on the words on conditions or otherwise.
And all of those things that flow from it. And even if I put aside Section 38 and you take me to Section 54, then I have an even stronger case for discretion, because A, it says so. I mean, putting aside my argument that shall in Section 38 means may when you come to conditions, but in Section 54, may does mean may, and that's entirely in my favor. And even if I am wrong as to my primary submission, that is to say that the discretion there was a standalone one without any regard to the appointment of a receiver, if I take that against me, I say with respect that this was an opportunity or an occasion whereby the court could have done both, stayed and appointed the receiver in a case where there is no issue as to the availability of a rental income. So if they want to make a decision that they prefer to collect the income and not let it go to Heaven Heights, that was open to them. So that's all I wish to say about Section 54. And
Well,
then
it should have appointed a receiver and pending, stayed
the
sale,
sale.
pending what?
pending the sale of Heaven Heights.
By the bank?
By the bank.
My
friend says they're not a bank, so I'll take him at his word.
By GAM.
By GAM, absolutely.
I see.
Absolutely. And I'll go further. If everything that my friend has said against me in relation to the saleability of Heaven Heights is right, let's assume that. I don't accept it, but let's assume that that is right, then all that Mrs. Deslauriers was really arguing for was, if you think you can do better, you've got a power of sale, you've got an order for possession, go ahead. If it's not sold, then within a reasonable time, 6, 8, 9 months, whatever the appropriate time is, while you're receiving the rents, then you can come and sell Victoria Square. And the reason for making that application is because Victoria Square, on everybody's case, could never have satisfied the debt. And as far as residual value...
What's the value on Victoria Square?
Well, even on my case, it's 18 million. On their case, it's 16 million. And the debt is...
Yes, quite.
So it's an argument about not very much in that respect. My Lords, last point, and I'm about to run out of time. Can I just ask you to look at page 89 of the annexure to my friend's written case? And what that is, it is a valuation that's not in contest. So I'm on Heaven Heights, and my Lords will remember that my friend annexed an affidavit, or series of affidavits, another document.
Yep, right, yes.
And it's just that single page, and I say two things about it, both of which you know already. The first is that the value there in 2009 is 39.8 million. So that's Heaven Heights. So let's leave aside the 77 million about which we get.
Where do we see, page 89, where do we see 39 million?
So, my Lord, it's the second substantive paragraph under valuation opinions. So, my Lord, I'm on the annexure to my friend's written case.
I think it may be page 90.
Page 90, right.
Oh, I'm sorry.
Yes.
Well,
Yeah.
mine says 89, so I apologize
Yes,
if I've got the wrong page.
Right.
Am I looking at the right thing, valuation opinions, my
Yep.
Lord Briggs?
Yep,
Yeah.
we got it, yep.
So that it's 39.8 million. Can I ask my Lord to note the date? It's the 2nd of February, 2009.
Yes.
It's 3 days after CLICO. And if you want to make good that, go back to the previous page, and can I read it to my Lords? However, the events of 30th of January have to be considered in arriving at an estimate of where the market for these units now stands. There can be no doubt that the insolvency of the CL Financial Group and all the consequences of that have adversely affected confidence. So that one would expect a sensible, competent valuer who's up to this point, none of his valuations have been challenged. The only one that's challenged is one that comes 5 years later, February 2014, I think. It's 77 million. Nobody is suggesting that the effects of CLICO are still in the same traumatic emergency triage stage as they must have been within the days of the announcement. And therefore, the valuation, even taking on board against me everything that my friend says about residual value and so on, I don't accept what he said to you as right, but you can test that in due course. We simply say that a discounted valuation is at the level of 39 million, and I'm optimistic one was at the level of 77 million. At the time, they were both in excess of the debt. My Lords, unless I can assist you further,
No, thank you very much. And,
Obliged, most grateful. I'm sorry to have gone over the time.
no, I think well done. The board is very grateful to council for their submissions, even if they have felt a certain pressure of time. The board will take time to consider its judgment.